Hey guys, welcome back. Joe Brunsman, insurance broker to the stars here. A painfully boring yet hopefully surprisingly useful contract term review for MSPs. The reason I'm making this is I've seen kind of a rash of contracts coming out where MSPs are agreeing to things that could potentially come back to bite them later on. So I want to make sure that the community kind of like you just get a basic primer, like a plain English explanation for a lot of the common contract terms that we're going to see. And then hopefully you can pass that on to your sales team so that people aren't agreeing to things that you can't actually provide for. All right, starting off with the basics here. Occurrence versus aggregate. Occurrence is per claim as far as your insurance goes. Aggregate is the total limit, how much they'll pay out in a year. So you could have a 1-1, which is a 1 million per claim, 2 million aggregate, or you could have a, let's say a 3-6, 3 million per claim, 6 million aggregate. When, as just a quick aside here, when you're looking through those contract terms, if they're asking for just absurd amounts of insurance, the way the game is generally played, if they have in-house legal counsel, is in-house legal counsel, they just start off asking for the moon, and then it kind of gets whittled down from there. I think that's generally a stupid way to do it. I mean, just ask for what you need and then talk about it. But I've seen some really crazy insurance requirements, 10, 20 million as far as tech E&O goes. That's going to be really, really expensive. So before you guys start signing or agreeing to any insurance, go to your insurance broker. I do this all the time as an insurance guy, right? Client comes to me, they're like, hey, this contract's requiring, say, $4 million in tech E&O. And I say, hey, before you sign that, let's just get a ballpark figure from the underwriter to see how much that's going to cost you. I actually talked to an MSP a couple weeks ago, and they actually agreed to an amount of insurance. They signed the contract. Then they figured out, oh my God, the insurance actually costs more than what we're going to get for the totality of this contract. All right, so don't put yourself in that position. I'll say, I give you permission to push back on insane insurance limits requests. All right, professional liability and errors and omissions. What's the difference? Well, they're generally synonymous terms. All right. So when you see those, they pretty much just go hand in hand. All right, next, we see requests for cyber insurance. Now, as a quick aside here, you guys should have, as MSPs, a tech E&O policy. Very rare that you're going to have an E&O policy and a separate cyber policy. That could get you into a lot of trouble for a bunch of reasons. So once you're done with this video, go back to your tech E&O policy, make sure you have E&O coverage and you have cyber coverage. Now, within contracts, we'll see various terms, and it's hard to narrow this down because these are not defined in statute anywhere. So what we'll see are things like privacy liability coverage, network security liability coverage. What are they getting at there? Privacy liability, generally that's like third-party stuff. So think like class action claims, regulators coming after you, and also occasionally ask for like media liability stuff, but that's pretty rare. And then they'll ask for network security liability. So there, think costs dealing with a cyber event, at least on the front ends, like attorney, forensics, business interruption, those types of costs. All right, retroactive date. Please do not lose your retroactive date. That effectively says, hey, this is how far back we will cover you for services you render if a claim pops up. All right, there's the big long explanation. If you want to read it, you can pause the video here. But if you don't renew your insurance on time, you could lose your retroactive coverage. That's a big problem specifically for MSPs. One, if you have a contractual requirement, you're really in a bind there, and it's almost impossible to fix depending upon how far back you lost that coverage. But let's say you have your tech E&O policy, you don't want to renew it, or it just kind of falls in the cracks, and then 3 weeks later, you're like, I guess I better have that stuff. Well, all the retroactive coverage that you had under that previous policy, you're probably not going to get that back. That could be a problem because let's say 6 months ago, your client had a network intrusion. Then, you let your policy lapse, so you lose all your retroactive coverage. You buy a new policy, and then they go, hey, oh my God, 180 days later, they're like, you know what? Turns out we actually did have a data breach, and now we're going to bring a claim against our MSP. Your insurance provider could sit there and go, well, no, because we're only covering you for work that you perform from that retroactive date moving forward, not the retroactive date moving backwards. So they could try and deny you on a claim there. It's also important that if you're an MSP watching this and you don't have tech E&O insurance, recommend you get the right policy sooner rather than later because you really want to keep that retroactive coverage for as long as possible. All right, trail-offs. I wasn't sure what the technical term for this was. I couldn't find it in any of my nerdy insurance or contract law books, but you'll see some requirement where it's like, hey, you have to keep insurance that we're requiring in place for X number of years after the termination of the contract. Now, it makes sense from your client's perspective because they're trying to preserve their rights in the future after the contract is over. And they want to be able to recoup those funds if they need them. But you got to be careful with how long that time is. Because it's not uncommon that when you go to sign that contract, if they're like, hey, we want you to have $4 million in tech E&O insurance. And you're like, all right, cool. Well, it only costs this much and we're making like this much in MRR from this client. And so, yeah, it totally makes sense. But when you stretch that after the contract's over, you're not getting paid anymore, but you still got to keep, in this example, that $4 million policy, that really starts eroding your profits. All right, so please be careful with how long you're agreeing to what. All right, next, mediation and arbitration. So I often see these confused or people just don't generally kind of understand what they mean. This is outside of litigation, so outside of filing papers in court. So mediation, think of this, I like to think of mediation and arbitration as kind of like mom and dad. So mediation would be like my two sons are fighting over Star Wars Legos and mom goes, okay, boys, sit down. All right, Christian, tell me what's going on. Will, tell me what's going on. All right, guys, maybe, you could have this Lego and you could have the other Lego. And is everybody going to be happy? And they go, yeah, okay, great. And then they leave, right? Generally, it's also non-binding, so it's not like a true legal agreement. Much softer way to go about things. Generally, if you're going to see arbitration, that's going to be for some type of work dispute or contract dispute where you want to keep the client, but you got to get something hashed out. Arbitration, on the other hand, that's like dad sitting down and dad going, all right, son number one, what's your side of the story? Son number two, what's your side of the story? And then dad just makes a verdict, right? And dad goes, well, here's what's going to happen moving forward. All right, so generally arbitration is binding. Think of that as like a legal agreement. And often the arbiters, so the third party in the middle, they could be like a retired judge. There's a bunch of ways to split that cat. There's whole books written on this stuff, but that's the gist of it. All right, joint and several liability. So you're going to find this in roughly 46 of 50 states, and it's where multiple parties are held responsible for the damages as a group. But each party is also individually responsible for the full amount of the damages. So what does that mean in English? So if one party is unable to pay, the other parties are all liable for the full amount, regardless of how much they were involved. So this is where you'll see multiple parties brought into a claim because something happened with the computer system, and the court system's going, all right, we want to make the guy that got damaged whole again, and then once all you guys pay out, we'll let your insurance companies figure out who's really responsible for what, and they'll figure all that stuff out on the back end. All right, hold harmless and indemnification agreements. effectively, this is just a promise between two people, right? And all it says is, hey, if one person has to pay money for a claim, the other person's going to take care of it for them. You will often find this or let me give an example first, right? So the client holds, you'll find this in the MSA, client holds the MSP harmless and agrees to indemnify them against third-party actions dealing with bodily injury, property damage, if a client, in this case the client, is found negligent. All right, next, additional insured, what and why? And this is really getting into the meat and potatoes of those contract terms. So basically, additional insured, if somebody's requesting to be considered an additional insured, what they're saying is, hey, I want your policy to be my policy. And that's why you got to be careful with that. If they want to do that, you need to seek underwriter approval, and it could cost extra. Now, if you're a SaaS provider, it could make sense to do this because, some bank, for example, goes, hey, you know what? Yeah, we're going to pay you tons of cash. We're going to get your financial software. We're going to be using that. But if something happens, because we're not overseeing as a bank, we're not keeping track of if things are getting patched. We don't know if there's 0-day vulnerabilities. We didn't write any of the code. So like if we get hit because of some vulnerability in your software, we want your policy to pay out for that. So you could see why that would cost extra because the insurance company is potentially bringing on additional risk that they initially did not agree to. Now, if you're an MSP, adding someone as an additional insured may not make sense. And the reason for that is you can't sue yourself. So if they're an additional insured under your policy, well then, because you can't sue yourself, something happens, a client tries to sue you, your policy is going to go, hey, well, that's excluded. And that kind of screws you over and it kind of screws them over because they want to recoup the money and you want your policy to respond. And now nobody's going to be happy. All right, so be careful about that additional insured request. Next, primary non-contributory. So effectively they're saying, hey, if something happens, we want your policy to be the primary policy that pays out. All right, there's a whole brief spiel there. You can pause the video here if you want to watch it. But once again, you have to seek underwriter approval to do this because it could cost extra money. The insurance company could be bringing on additional risk that they initially didn't bargain for. And once again, they don't have to agree to this. Same with the additional insured provision. So they don't have to agree to primary non-contributory. They don't have to agree to additional insured. So please don't sign a contract saying you're going to do this and then go talk to the insurance company. Come to the insurance brokers first. We have to go back out to the underwriter, explain the situation, provide generally a snippet of that contract that's asking for the primary non-contributory. All right, waiver of subrogation. Your insurer cannot try and recover from me or my insurance policy or my insurance company. So what is subrogation? It's effectively an insurance company stepping in the shoes of an individual right after the insurance company's paid out, using that person's individual rights to go and sue somebody else. Now, once again, you have to ask for permission. You need underwriter approval. It could cost extra. Let me explain it a different way for you. So imagine, obviously you're an MSP and your client has cyber insurance. They get hit with whatever, right? Business email compromise, ransomware, data breach, whatever. So then their cyber insurance company pays out all the money associated with that claim. While the cyber insurer is investigating this particular event, they find out that maybe a couple things happened. You didn't actually configure the firewall. Maybe you didn't have backups enabled, even though you said you were going to have backups, so it cost the insurance company extra money. Well, the insurance company, the cyber company, they're going to pay out all that money. Then they could turn around and say, hey, you know what, MSP, we just paid out all this money. We think you were negligent. And so now we're going to subrogate the rights of our insured. And as an insurance company, we're going to act in our client's name. We're going to come after your policy to try and recoup all the money that we paid out for this. You'll often see this as another example in the car insurance world. All right. So, let's say you're just, you're parked on the side of the road and someone comes by and they slam into the side of your vehicle and they tear the whole thing up, right? You call your insurance company goes, hey, you know what? Don't worry. You're not going to have to pay for this. You don't have to pay your deductible. We'll go ahead and pay for the cost to get this thing replaced. Well, then in the background, your insurance company is subrogating rights against their insurance company, and your insurance company is going to try and get back all the money they paid out under your policy. And then you'll see here why you need that approval. Very common clause here. This is a subrogation clause. You must do nothing to impair such rights. And then you'll see at our request, you will bring suit or transfer those rights to us and help us enforce them. Hence, subrogation of rights. All right, next, subrogation and additional insureds. Now, if you do find yourself in a position where it actually makes sense to do this and you're going to go through with it, and you've gotten all the approvals, et cetera, it's a smart choice from your client's perspective, because generally an insurance company is forbidden from subrogating against their own insureds or against their own additional insureds, right? So it's hard for an insurance company to go back and sue the policyholder. Now, just by adding the additional insured language, it's strong. So sometimes we'll see, hey, we want additional insured, primary non-contributory, but they don't ask for a waiver of subrogation. That's on them. But often you're going to see additional insured and subrogation of rights included, right? So there's the reason they do that. I don't want to belabor the point, but there's a bunch of different examples of kind of these niche cases where insurance companies have gone back and subrogated rights against additional insureds, but that's like PhD level stuff. And I'll end it there. All right. So putting all this together, client requests additional insured. They go, hey, we want your policy to be our policy when something goes down. Next, primary non-contributory. If a claim pops off, we want your policy to pay out first. And then our policy could kind of act like an excess insurance of sorts if your policy gets completely wiped out with payments and defense expenses, all that kind of jazz. And then a waiver of subrogation. Right, your policy was our policy. Your policy paid out first. Your policy, your insurance company lost all that money. We don't want your insurance company coming back against our insurance company or our business to try and recoup those funds. All right, force majeure. What is force majeure? It's a very fancy pants French term, which effectively just means superior force. Now, why do many contracts or most contracts probably have some force majeure clause? It has to deal with some circumstance that is just completely outside the control of the parties, where something could happen where one of the parties would technically be in breach of contract, but it's kind of like an act of God. So you wouldn't necessarily want someone to be held liable for that. So an example would be, pandemics, might be too soon, natural disasters, wars, etc. So let's say you're storing a bunch of data at a data center, right? And that data center gets wiped out by a tsunami. Well, yeah, they're technically in breach of contract, but it's such a freak event that nobody could really plan for or forecast that they could effectively get out of the contract. All right. Certificates of insurance and proof of insurance. So very commonly we'll see with all of these contract provisions, like, hey, we want proof of insurance. Sometimes we'll also have MSPs requiring proof of insurance of their own clients. Now, what is a certificate of insurance? Certificate of insurance is kind of the general idea of that demonstrates proof of insurance. A certificate of insurance is just a snapshot on a piece of paper. That's it. It looks really official. It's just a snapshot. It's just evidence of coverage. You're demonstrating basic elements. So there's numerous boxes on there. So you're going to have, hey, what's the insurance company? What's the type of insurance? What are the limits of insurance that are being carried? And then there's like an other box where you could talk about if someone's additional insured or primary non-contributory, or if there's a waiver of subrogation, it could get into that stuff. But once again, it is a basic snapshot. All right. It doesn't really get into, hey, only half this policy is left because they already have a claim. It's, hey, this is the snapshot of what they bought. All right. So don't get too wrapped around the axle as far as certificate of insurance goes. Why did this render weird? Anyways, if you're still with me 20 minutes in. All right. Limitation of liability clause limits the amount of damage that a party can try and recoup. Right. So you're often going to have this within your MSA. Now, you want to have this to protect yourself from some excessive financial exposure. A few weeks ago, I think it was, on Tech Tribe, somebody said, hey, I got this new potential client, but their attorney wants to completely wipe out the limitation of liability clause. And I said, that is patently insane. That attorney should probably be fired. And that's just not how business is done. All right, so you're almost always going to see a limitation of liability clause within your contracts. Please don't let the sales team just redline that out, because you could be really on the hook for some big bucks. Now, generally speaking, these things are enforceable, but it's not always going to be the case, right? There's always an exception, or to sound like an attorney, it depends. All right, so there's going to be specific language, specific state requirements, and then they could try and overcome that with allegations of, at the bottom there, gross negligence, fraud, violation of law, that type of stuff. But generally, if they're doing the gross negligence, that's a much higher bar to clear than just normal run-of-the-mill negligence. So I'll go on a limb here and say the preponderance of cases, the limitation of liability clause is probably going to be the limitation of liability. All right, next, liability waivers. And this is different than a limitation of liability. I actually have a whole video on this. I'll link to it actually right above. And it's just a legal document, protects a person or entity from being held responsible for certain types of damages or injuries. So an example of this would be, hey, your client's bookkeeper, the famous bookkeeper, refuses to have MFA for email access. And you're sitting there as an MSP and you're like, oh my God, that is one of the dumbest ideas I've ever heard. But your client goes, hey, can you make that happen? And you go, well, yeah, we can do it. But you're sitting there as an MSP going, what happens when inevitably they get phished and they wire money to somewhere it's not supposed to go, right? We as an MSP don't want to be held liable for that stuff. So it's effectively just a document. It's just a waiver of liability. Now, there are very specific rules to this. They get down to the state level, and there's a bunch of case law at the state level, and it's what can be in there, what can't be in there, what has to be said, if things have to be in all uppercase, or if it has to be in uppercase and bold or italics. It's something that your general attorney should be able to assist you with. All right, so if you get into the liability waivers, just talk to your attorney. All right, so moving forward here, once again, I am not your attorney. I am an insurance broker. So I'm not giving you legal advice. I just wanted to give you the 80-20 rundown of what are these most common contract terms that I'm seeing. And hopefully I was able to translate those into plain English that everybody could understand. All right, keep in mind that if someone's requiring additional insured, primary non-contributory, waiver of subrogation, you want to run that through, or anything else that's kind of out of the norm there. You want to run that through your underwriter at the insurance company to make sure that you're not agreeing to something that you actually cannot agree to. All right. Also, you can always have your own legal counsel take a look at this stuff. And kind of as a closing note here, please discuss this with your sales team. I have seen a couple instances where the sales guys, they wanted to close that sale. It was a big dollar amount, and they said, all right, you know what, we'll cross out the limitation of liability, right? You don't want to put yourself in that position. So please make sure your sales team, as they're reviewing these contracts, that, and you as probably the owner watching this, that you actually understand, hey, kind of what's okay to do, what's not okay to do, what is just absolutely verboten. And hopefully this presentation helped you there. All right, with that, if you like this, found it useful, you learned something today, please like, share, comment, subscribe, what all the YouTube people say. Share with your friends to make sure they're not doing anything crazy. Right above me is another video that the YouTube algorithm will recommend to you. And then if you click over there on my beautiful face, you can subscribe to my channel. All right, guys, with that, stay safe.